Well, the U.S. Tax Court issued a significant opinion last week that provides relief from self-employment tax on land rents in certain situations. Self-employment tax applies to income that is derived from a trade or business. So joining us now is Kansas Farm Bureau Professor of Agricultural Law and Taxation at the Washburn University School of Law, Roger McEowen. Well, Roger, thank you for joining us once again. Now, farm tax practitioners, they'll recognize, of course, the case name of Mizell, which is one of the most significant farm tax cases from the past several decades, I understand. Can you give us maybe a recap of that case for better understanding?
Sure. Good morning, Janet. It's a pleasure to talk about this. This is a big win in the tax court last week involving this case known as Mizell that was decided by the tax court back in 1995 involving an Arkansas farmer. And it involved the common structural setup that we see with respect to a lot of farming operations across the country, where the landlord, the owner of the farmland, will rent the land to an entity in which the landlord is also participating and has two agreements. One is the employment agreement for the operational entity, and the other, of course, is the lease agreement for the lease of the land to the entity. And the tax court said in that situation, agreeing with the IRS, that even if that lease was a passive lease, either a non-material participation crop share lease or a cash rent lease, it was still subject to self-employment tax because they were wrapping it together with the employment agreement. And that was a big blow to that type of a structure all across the country.
So again, the type of lease or the rate of rent charged under that lease, how much does that matter?
Well, based on Mizell, it didn't matter until we got an Eighth Circuit opinion that modified the tax court's decision a little bit about 15 years ago. And what the court said in the Eighth Circuit was if the land rent lease income was representative of a fair market rate of rent, then that lease stood separate and apart from the employment agreement. And if the lease was passive, it was not subject, the income under that was not subject to self-employment tax.
So what is the takeaway from all of this for our farmers and ranchers tuning in?
Well, last week, Judge Paris on the U.S. Tax Court applied that Eighth Circuit exception to the Mizell decision outside of the Eighth Circuit involving a Texas farmer who did not have counsel representing himself against the IRS in the tax court. And she said, no, we're going to follow the Eighth Circuit opinion outside the Eighth Circuit. And so this is a full tax court opinion which has national application. And so there are audits on this issue across the country outside the Eighth Circuit. And now farmers have some ammunition to fire back at the IRS on this theory that Mizell perhaps is no longer valid. So it's a good development. I would encourage farmers and ranchers that have this structural setup on their farms and ranches for tax purposes to consult their tax advisors.
All right, Roger, thank you once again for your insight. Again, Kansas Farm Bureau Professor of Agricultural Law and Taxation at the Washburn University School of Law, Roger McEowen, joining us on the phone from Topeka, Kansas.